Hey, TikTok. Good morning. I'm going to get this started in just a minute. I'm just waiting for my other streaming platform to get rolling. The joys of having multiple pieces of technology rolling at the same time. Hi, folks. Good morning. My name is Greg McLawsen. I'm the Affidavit of Support lawyer. I help green card holders enforce rights under the USCIS Form I-864. I litigate these claims in federal court all across the country. But I am going to talk today about a case that is not my lawsuit. I just came across it because I'm trying to do a series of videos on other cases that have come out in the past year or so, provide some updates about what's been going on in this area of law. And oh my goodness, this one is a cautionary tale if I've ever seen one. So let me kind of go through some basics of what happened in this affidavit of support lawsuit, and then I'm going to draw out kind of some contrasts between the dumpster fire that this lawsuit has become and what a good lawyer representing a defendant would do in a similar situation. So again, the main lawsuit that I'm talking about here was not mine. I was not involved in any way, shape, or form, but it's an interesting one. So this is the Bitton v. Jackson case, Bitton, Biton v. Jackson. It's a case out of the Western District of Oklahoma. I could be wrong, but I think this is the first affidavit of support enforcement lawsuit that's been litigated in the state of Arizona. Please correct me if I'm wrong. The plaintiff has been through a couple of different attorneys, but is currently represented by the Black Box Legal Group out of Norman, Oklahoma. I'm not familiar with them, but credit to these guys. They are sticking with it. This is a frustrating case, and it's a good example of tenacious lawyers representing a low-income affidavit of support plaintiff. I hear you guys. I see you. That is a familiar role to me to be playing. So here's kind of the basics of what happened in this case. The lawsuit was filed in October of 2023, so almost exactly 2 years ago. And it looks like the defendant did not appear in the case. The way that lawsuits work is you file the complaint sets forth your claim, in this case, under the affidavit of support. It's a pretty basic document, but it basically gives the legal foundation for your entitlement to support under the affidavit. You always describe your income and that there's been no payment by the affidavit of support sponsor. That's what entitles somebody to damages or a financial award from a court under the affidavit of support. They basically tell the court, look, the sponsor signed the affidavit of support, didn't comply with it. My income has been below 125% of the poverty guideline, and the sponsor didn't provide support. That's the basics of an affidavit of support claim. You, as the plaintiff or as the plaintiff's attorney, then serve that lawsuit on the defendant. You serve it along with something called a summons. A summons tells the defendant, hey, defendant, you are getting sued in federal court and you got to show up and defend this lawsuit, or a judgment is going to get entered against you regardless of your involvement. And in this case, the defendant did not answer. So the court entered something called a default and then a default judgment. That's what happens when you don't show up and defend a lawsuit. A court under Civil Rule 55 first enters a default saying that you failed to appear, and then the plaintiff shows the court what they are entitled to in damages, and then a default judgment gets entered. So all of that happened in early 2024. I've said this a million times to a million clients and in a bunch of videos, but getting a judgment from a court is not the same thing as getting paid. I will say that one more time. Getting a judgment is not the same thing as getting paid. A judgment is the federal court's adjudication that you are owed a certain amount of money. But you, the plaintiff, still have to go out and get that judgment collected from the defendant. And the past almost 2 years, this affidavit of support plaintiff in Oklahoma has had their judgment and has been trying to make good on it from the defense. This judgment in the Bitten litigation involved what I typically see in my own affidavit of support cases, which is an award of damages. So that's the money that's owed based on the difference between the plaintiff's income and 125% of the poverty guideline. That's the financial judgment. And the judgment also ordered the defendant to comply with his affidavit of support, because the affidavit of support obligation, it's not a one and done situation. It carries on until the affidavit of support ends by virtue of the 5 events that are defined by federal law. That's primarily when the affidavit of support beneficiary gets U.S. citizenship or has 10 years of work history. So the judgment in the Bitten litigation did what most of the judgments in my lawsuits say, and told the defendant to comply with this obligation until the affidavit of support terminated. It specifically required him to pay support that was owed every month by the 5th calendar day of the month. And that didn't happen. So, I mean, where to even start with this? Along the way, the defense attorney who ended up representing this defendant managed to get himself sanctioned. And a sanction is basically a punishment by a court. Lawyers, I mean, there are a lot of lawyer jokes out there, but lawyers are held to a very, very stringent standard of conduct. And if you don't keep your nose clean, you can get in big trouble in court. And this attorney representing the defendant failed to show up for a status conference that was ordered by the judge. And if you want to make a judge mad, try not showing up for a court hearing when the judge tells you to show up. That's what happened here. It gets better. So the court ordered him to pay a financial fine for not appearing for that status conference. That's relatively unusual. I mean, it's a big deal to get a financial sanction by the court. And then the defense attorney didn't pay the amount that was sanctioned by the court. So the guy got a fine entered against him and he didn't pay it. If you think that makes the court happy, think again. So the court entered another order, finding him in contempt for violating the sanction order. It did not award additional sanctions, but basically he got in trouble twice, once for not showing up for the hearing and another time for not paying the fine that he was supposed to pay. Along the way, while this is all happening, we have a variety of different enforcement mechanisms that have been pursued by the team representing the plaintiff in this matter. So we have garnishment going against the guy's VA benefits, and this runs into all sorts of procedural complications because federal courts have to issue garnishment orders in compliance with Oklahoma law. So there's an issue about how the garnishment was going to happen in a way that was compliant with Oklahoma law. On top of that, and this is kind of the big one, there was a contempt motion brought against the defendant because in the United States, you cannot generally be jailed for failing to pay a debt. So if I buy myself another motorcycle, which I'm not going to do, I will go on the record, I'm not buying another motorcycle, but if I buy a Harley and take out a loan to pay for it, and I don't pay that loan, I can't go to jail for that, right? The Harley dealership can't come and put handcuffs on me and throw me in jail. That's not allowed in the United States. But if a court directs you to do something, in this case, the Bitten court in Oklahoma ordered the defendant to pay financial support on a monthly basis. That is different than a pure financial judgment. Excuse me. That's different than a pure financial judgment. That is a direct order from a federal court telling the defendant to take a particular course of action. If you don't do that, you can get in trouble, and that trouble can potentially land you in jail. I've only seen this happen once in an affidavit of support lawsuit. And I was talking about this in a federal court mediation yesterday. But we had a judge in the Eastern District of Texas issue an arrest warrant in this sort of situation we're talking about here, where there was a judgment that entered and also ordered the defendant sponsor to comply with the affidavit of support. He didn't do that. We gave him lots of chances. And the judge eventually, pardon me, it's that time of year. When he didn't comply with the judge's order to make these monthly support payments, the federal court said, U.S. Marshals, here's an arrest warrant. You go out and get the guy and throw him in jail. So we have that sort of relief being pursued against the defendant in the Jackson litigation. So what a mess. I mean, we have basically a year and a half plus of litigation. The judgment has already been entered. So the core amount of financial obligation, which was around $50,000, was adjudicated early on. And the guy hasn't complied with that at all. Because of this decision to fight and fight, legal fees are continuing to mount. So this defendant sponsor has presumably paid his own attorney, who, I mean, this is my opinion from having looked at the docket, seems to have messed up in a way that was significant enough to get him sanctioned by the court. So the defendant's paying his attorney. The affidavit of support includes an attorney fee provision. So it means that the folks at Black Box Legal who've been working so hard on this case, they are going to be able to get an additional fee award for all of their time. And on top of all of that, damages under the affidavit of support are continuing to accrue because Judge Polk, almost 2 years ago, ordered this defendant to continue making support payments under the affidavit, which he hasn't been doing. So you got the $55,000. You got more damages that are accruing. You've got attorney fees being paid to the defendant, and you've got attorney fees being owed to the plaintiff's counsel. So what a mess. What a mess. And it's not a good situation, of course, for the plaintiff either, because the plaintiff brought this lawsuit because she was entitled to basically subsistence level financial support from the sponsor. The whole reason the affidavit of support exists is to make a sponsor provide just barely enough financial support to lift somebody out of poverty. And that hasn't been happening. So all along, this poor person has been in a truly desperate situation with a sponsor who is just flagrantly violating a court's order and not providing support. I want to contrast that to a case that I resolved recently. And I'm not going to mention the case name. I don't want to breach client confidence in this matter. But we had a really similar situation where a sponsor defendant failed to respond to our demand letters, multiple demand letters. Then we filed the lawsuit. We served him with that summons and complaint that I discussed earlier. The sponsor didn't appear in the litigation, and so we got a judgment against him. Right while we were in the process of finalizing that judgment, the court wanted some additional information before entering the final judgment. The defendant appeared through an attorney. Now, he could have taken that in a couple directions. He could have done some version of what the defendant sponsor did in this Bitten v. Jackson litigation. He could have taken the strategic choice of saying, okay, well, I got a judgment entered against me, but I am going to make this as hard as possible for the plaintiff, in that case, technically called a judgment creditor because the judgment has already entered. The defendant could have said, look, I'm going to make this as hard as possible and as painful as possible for them to pursue. That's what's happening in the Bitton v. Jackson litigation. Whether it's an emotional decision or a tactical legal decision, the defendant in that litigation is taking the approach of making things as painful as possible for the plaintiff's team to collect a single dollar from him. And that has landed his attorney in court with sanctions and has massively, increased the legal expenses in that case. By contrast, this case that I was mentioning just a moment ago, where we got the judgment against the sponsor, he got a good attorney. He got a practical-minded attorney, and the first thing the guy did was pick up the phone and call me and say, let's figure out if we can figure out a way to get this resolved that doesn't result in years more of litigation, tens or 20, multiple times $20,000 of legal fees on both sides of the case. And we hit pause. We told the judge in this other case, Your Honor, defense counsel has just appeared in this matter, and we think that we have an opportunity to get the matter resolved. So in very short order, the federal judge hit pause on the case, said, don't have to send us any briefing. Instead, go to mediation. So we got sent over to a magistrate judge for a settlement conference. Magistrate judges are a type of judge in federal district court, and they typically are the ones who handle settlement conferences in the case. These conferences don't cost the parties anything. It is a service that is offered by almost all federal courts. Not every single one, but almost all federal courts will make a magistrate judge available. So we spent under 3 hours in a mediation before the magistrate judge. The mediation didn't cost my client anything. It didn't cost the defense anything. Obviously, the attorneys are going to get paid for their time, but there's no cost to paying the mediator. And in less than 3 hours, the other attorney and I figured out a resolution to the case. There won't be a single additional document filed in that case, aside from the notice of settlement and the dismissal in that litigation. And instead of spending years and tons more money, it's just going to go away. And the defendant is going to pay the money that's owed under the judgment, and we're done. So, of course, as a plaintiff's attorney in these lawsuits, I represent Affidavit beneficiaries. I'm representing the green card holders. I sue sponsors. That is my job. Of course, it is better for my clients if they have a known path to getting paid. But my goodness, it is better for the sponsors too. The defendant in that litigation that I'm handling, the one that settled after judgment, he's going to pay some money. He'll pay the money and he will be fine and he will move on and everybody will move on and the next chapter of their lives will be able to start. This defendant in the Jackson litigation, he's 2 years out from the lawsuit having started. And not only is it not done, he is digging himself deeper and deeper and deeper into debt. His attorneys are getting in trouble. He's, as far as I can tell, he's very likely to be hit with a contempt citation here in the near future. It is absolutely within the realm of possibility that he's going to go to jail. At the very least, he is going to end up paying, I would guess, at the very least, twice the judgment amount and probably 3 to 4 times. So taking that scorched earth, obstructionist, fight at every stage approach is going to be a disaster for this guy. And I mean, again, I don't know the individuals in this case. I don't know how much of that was legal advice that he relied on versus feeling emotional about the case. But this is just an absolutely prime example of what not to do here. And, I get it. I was in a mediation yesterday, different case from the one I mentioned a moment ago. I was in a federal district court mediation yesterday in another affidavit of support case. And my client, at my advice, accepted a settlement offer that we didn't like. I think she was owed more money than that. And, if you look at it purely in terms of rights and pure legal analysis, like a first-year law student might, it's a settlement in that case that looks bad on paper. The real world doesn't exist in a law book. And it is often the case for both parties in these litigations, in these types of litigation, that you have to compromise. You have to hold your nose, not because, let me put it a different way. When you're viewing the possibility of resolution, it's not always the best approach to look at it in terms of what you're owed. What you should be looking at on both sides of the case, from the plaintiff's perspective and from the defendant's perspective, is I'm in this situation now. This is the reality of my situation, and there's the reality on the defendant's side of what their financial ability is and what they're going to be able to pay. And arguing about rights and what the law requires is not always the best approach, as against sitting down to the table and figuring out what deal is actually achievable by the parties, getting that deal done and moving on. If the defendant in this Jackson litigation had taken a practical-minded approach to this 2 years ago, what probably would have ended up happening is, as one federal judge put it to me in a mediation, it's not a settlement agreement unless everybody goes away a little bit pissed off. And what she meant was, in a real world situation, everybody gives something that they don't want to give in a negotiation, and everybody gets a little bit less than what they want. So in the Jackson litigation, if the defendant had come to the bargaining table after that judgment was entered, maybe the plaintiff would have walked away with less than what she was owed on paper, but she would have gotten paid. She would have had a path forward to getting paid. And at this point, 2 years out, maybe the whole thing would be done. The defendant would have paid more than he wanted to, because he wanted to pay $0. But he would have come to the table, if he had been smart, and would have paid something that was acceptable and doable, and he would have gotten out from under this obligation. Instead, he dug in his heels, has fought and fought and fought, and he is in an incalculably worse situation now than he was then. It's getting worse and worse and worse and worse. So I've said my piece on this, but this is going to go into my files. I have a whole list of cases that are cautionary tales in the affidavit of support arena. And this one is absolutely going into that bucket as one of the examples I will use when I talk to sponsors and their attorneys early in litigation and say, guys, please, let's hit pause and see if we have a path to resolution on this before we go scorched earth litigation on this. That is my standing policy in every single case I litigate, to extend that olive branch early and often and try to get parties to the table, because it's better for the defendants, but it's also better for my clients. So I will continue monitoring this Bitten v. Jackson litigation. I'm kind of morbidly curious to see what happens here. Again, my prediction is that this legal team for the plaintiff probably ends up securing a contempt order against the defendant. And I hope that wakes the guy up and the parties can get to the table and talk about resolution in this matter, because otherwise it's just going to keep getting worse and worse and worse. And hats off to the attorney that I litigated against in the other case, who took a totally different approach to this and did his client a real service by being practical instead of just belligerently combative. So, yay, practical lawyers. Find yourself a practical lawyer if you're a sponsor. Don't just fight for the sake of fighting. Hope that's helpful. If anyone has questions about the affidavit of support and enforcement issues, jump into the comments on YouTube or Facebook or TikTok. I'm pretty quick about answering those within 24 hours or so. If you've got an individualized case that you would like to talk to me about, I do free video consultations. You can book those on soundimmigration.com. Again, there's no charge for case assessments. My name is Greg McLawsen. I'm an attorney here in beautiful Washington State. Not so beautiful today. It's the beginning of fall, but hope everyone's doing well, and I will see you on videos later this week as I continue to work through case law updates. Take care, everyone.